Hello, I'm Glenda Clausell, an attorney here in Houston, Texas at the Clausell Law Firm. My practice areas include estate planning and probate.
And hello again, this is Mac Pierre-Louis, attorney at law and mediator. I am the civil and family law attorney at the Pierre-Louis & Associates PLC law firm in Houston, Texas. Today, we wanted to discuss some things about estate planning and the situation where there's a blended family. However, before we get into the topic of the day, we want to remind the audience that everything that is said today is meant to be for educational and informational purposes only and should not be considered to be legal advice. Also, everything that is discussed does not create an attorney-client relationship with anybody who might be watching or the attorney. So please consult an attorney if you seek legal advice. And with that, today, Glenda, thank you for being with me again. We're talking about the benefits of a will in a blended family situation. And by blended family, we mean where there might be stepchildren or a step-parent, a situation where there's an extended family, where there's multiple parties who might have an interest when there's a death, when wills are needing to be probated. So this is coming up as a topic because most of the country has, I guess, participated, so to speak, in the recent eulogizing or funerals that's happened involving the life of John McCain, Senator John McCain, and the singer-songwriter Aretha Franklin. This past weekend, for example, in Washington, D.C. and in Detroit, there was a lot of discussion over the lives of these two individuals. But one of the things that's come out is that John McCain had a will and Aretha Franklin did not. And also, they may or may not have had a blended families where multiple people might now be partakers or heirs of their estates. So we just want to talk a little bit about this trending topic and discuss the benefits of having a will when you are in a blended or mixed family situation. So Glenda, what can you tell us about the benefits of having a will in a blended family situation?
Thanks, Mac. I think when there are blended families involved and there is not any estate plan or there is not a will in place, you're inviting chaos, you're inviting drama. Now, when there are estate planning documents or will in place, then you relieve the drama of the families when it's time to mourn the deceased. So for those blended families, the course of action would be naturally to have an estate plan or a will in place.
Okay, so the bottom line is that chaos will ensue if a blended family, if the person who dies, who's in a blended family, does not have a will in place. So can you tell us any example stories that you might give to kind of illustrate this?
Right. One example that pops to mind is about two sisters. They were part of a blended family. The mom had a child, a prior relationship, as so did the dad. So when the last parent died, the sisters were fighting over control of this home, and they were at the point where you could not get the property sold because one sister refused to talk to the other sister. And so there's just property rotting away, and you're pretty sure that the parents wanted the daughters to share from the sale of the house, but because of one child's inaction, that's not going to happen anytime soon.
So are these kind of animus or these kind of conflicting relationships just kind of par for the course in these specific situations where, say, you have, example, husband and wife, they get a divorce, and husband get married to somebody else. Let's call that person B, that woman person B, and they have children. Well, if husband also had children with spouse A and husband dies, the interests between spouse A and the children of spouse B and spouse B and the children of spouse A might be conflicting.
They could be conflicting, but without a will, what you're looking at is the current spouse, the surviving spouse, having an interest in the estate along with all of the children. So the children are not going to be left out if there isn't a will.
So I have this scenario. Let's say a husband has children with a wife, and he divorces her, and then he remarries, but he has no children with the new wife. And so naturally there's going to be conflict where the children from the prior relationship are not necessarily going to trust the motives of the new spouse, the widow, correct?
Right, it happens.
Okay. And can you give us any other stories of where you've seen conflict in a blended family where there was no will?
Yeah, of course. You have instances where the children run to the bank and they want to close out all of dad's accounts, but you still have the surviving spouse who has access to those accounts, who is paying mortgage out of those accounts, who is putting their own money in those accounts. So what you have to have is a court action to make sure there is division of those sums for the children and for the surviving spouse. It's interesting to note that a lot of times the children look to basically wipe out any financial access to the surviving spouse. And that is one of the reasons that it's important for blended families, the husband, the wife, the parents, to make sure they have wills in place that take care of their spouses and also provide for the children.
Okay. So a lot of times whenever I think of blended families, I think of divorced parties. Okay. So let's talk real quick about the consequences of a divorce when you already had a will. First, let's start there. My understanding under the law is that when a divorce happened, the person who did the will, the interest of the other individual who they're divorcing is basically extinguished.
Correct.
Okay. But if there's children or other individuals who are mentioned in the will, their interest stays intact.
Right.
So what then is the, I guess, the goal? What's the best practice, in the instance where there is a divorce and there is a will, and then there's going to be a blended family situation? What should people do?
Basically, in those instances, I call them life changes. When someone dies, divorces, or there's a new child brought into the picture, you need to revise and update your will. You can remove people and you can add people. So when life changes occur, that's when you need to change your will.
Got it. Okay, well, Glenda, do you have anything else that you want to add to this topic of blended families?
Again, it's very important for blended families to make sure you take care of all of your family members, those from the prior relationship and also the current relationship, being sure not to overlook your current spouse.
All right. Well, with that, I'm Mac Pierre-Louis here with Glenda Clauzel, the Clauzel Law Firm, and we're going to leave you with our websites just so you can be able to reach us.
www.clausellawfirm.com.
And I'm MacPierre.com, and the information will be featured on the bottom of this video. Thanks so much. Hey everyone, Mac Pierre-Louis here again with Ms. Glenda Clauzel. Now we are switching modes a little bit to answer questions that people have sent in. By the way, if you have probate questions or family law questions or questions that specifically come to the intersection of probate and family law, please go ahead and message us. You can message Glenda at
713-228-2255.
You can text message your question and we'll respond back on maybe a possible future video. No guarantee we'll pick your question, but it might happen. Also, just remember, any answer is for informational and educational purposes only and should not be considered legal advice. All right, with that, got a question here. My adult child is ill and their estranged spouse has magically reappeared and now is trying to make important medical decisions. What should be done? Glenda?
Well, Mac, the first thing I would suggest someone would do is look to make sure there aren't any medical powers of attorney, directive to physician, living will, those sorts of things that have been executed by the ill child. And if there aren't those types of documents, have a conversation with the estranged spouse, letting them know, figuring out why they're there, and maybe that you two can work something out as you are both involved in making the medical decisions. Also, you should alert the staff the medical staff that the person is estranged and you're concerned about them making these decisions. It might not be in the best interest of your child. But note that the hospital, the medical staff will have to follow the rules set by the state, which include that the surviving spouse, the current spouse, is the one that they look to make those decisions without any documents on file.
All right, and with that, again, we're inviting you to message the offices, Pierre Associates PLC and the Clausel Law Firm. Again, the number you can message is
713-228-2255.
All right, and we're out. Thanks a lot.